present C category of employees who have been appointed, and we are now, my lord, in the clerks category, my lord, we are now all en bloc asked to leave under the judgment of the High Court. Now, my lord, there is no doubt that if there are irregularities, then Lord, one must be asked to go. It's very well, Lord Justice Sawant once put it brilliantly, that if you enter through back door, you must be prepared to go through back door. So, Lord, there is no doubt about it. But I'll be able to demonstrate to your lordships that there has been no serious inquiry here to go into the aspect as to what are the nature of the inquiries. So, my lord, here is a case where, my lord, there have been no serious inquiry or investigation by any, my lord, independent committee. There has been no serious effort, no actual inquiry to go into the, my lord, the actual aspect of the irregularities. Everything has been, my lord, said on the basis of this so-called, my lord, material which has been, my lord, received from this Pankaj Bansal, which CBI claims to have unearthed, my lord, in the course of its investigation. I'll deal with that. What CBI says is very crucial, and I'll, my lord, satisfy your lordships. Now, what is troublesome here is that your lordships have consistently held that if it is, my lord, there are large-scale irregularities, then everybody must go. But if there is possibility of, my lord, looking into and finding out whether who are the tainted people and who are not the tainted people, then what that, my lord, inquiry must take place. Because your lordship said that Article 14 clearly commands that those who are innocent cannot be made to suffer because of not some illegalities on the part of somebody else. But that's a consistent view that your lordships have taken. Lord, what my respectful submission is this, that the advertisement appeared in August of 2016. The first writ petition came to be filed in 2021. Now, my lord, during this large period, long period, my lord, lot went ahead. My lord, advertisement, my lord, was followed by written test, results, my lord, then my lord, typing and proficiency test, personality test, my lord, all that took place, first counseling, second counseling, third counseling, fourth counseling. Now, my lord, lakhs and lakhs of people had appeared. Lakhs and lakhs of people, almost something like 11 lakh people had appeared. Now, my lord, if for a long time, my lord, all these so-called petitioners who moved the High Court never ever thought it fit to go to the High Court. In the course of, my lord, this detailed exercise, after, my lord, the detailed exercise is complete, they move the High Court. Now, this is important. Writ petition 12266 of 2021 was filed because only allegation was that those who have been now sought to be empaneled after expiry of the panel, there was a very limited, my lord, challenge in that petition. They said, we are on the wait list, panel has expired. Why is it that some people who are now sought to be considered when panel has expired? So, my lord, that was the limited prayer in that writ petition on which this order was made by Justice Gangopadhyay for CBI investigation. There were no allegations of fraud. There was no prayer, my lord, to set aside all, my lord, appointments. Challenge was only for certain persons, perhaps 25 people, who they said are now included in this list, which was wrongly done. Now, my lord, that aspect has not unfortunately engaged attention of the High Court at all. Now, my lord, the other writ which was filed 12270, which my lord, comes, which is arising, which arises into this special petition where I am appearing. There also similar prayer, similar challenge, that these few people have now sought to be empaneled post, my lord, expiry of the. Now, just turn to, my lord, the everments of those two writ petition 12266. Just few, my lord, paragraphs. Kindly, my lord, volume 4 of the convenient compilation, page 1378. 1368. Sorry, 1368. 1368, my lord. And your lordships will find relevant paragraph at page 1461 first, para 7. Thanks, sir.
Yes.
Para 7, 1461. Your petitioners state that the result was published on 20th December. After declaration of result, petitioners found themselves in the waiting list category, but respondent authorities did not publish any panel as required by the said rules of 2009. Then please kindly omit the page and please see page 1462, para 11. Your petitioners state that because of the assurance given by respondent authorities, petitioners had legitimate expectation that petitioners will be called for counselling, but respondent authorities, although issued notifications for second, third and fourth phase of counselling, did not call your petitioners for counselling. Now, my lord, omit this. Please kindly turn to para 15. This is their gravamen of the charge, and learned single judge should have confined to this. Your petitioners state, para 15, my lords, that suddenly respondent authorities by memo number so-and-so dated 2nd September 2019 notified that waiting list panel in relation to Group D has expired. Be it mentioned here that although panel has stated expire on 4th of May, counselling was held even after the said date, and furthermore, panel was published only on June 2019. It's further stated that respondent authorities being statutory authority are under obligation to follow the relevant recruitment rules. Then we'll not omit all that, and please kindly turn to next page. Para 19. Your petitioner state that several candidates have been recommended for appointment to the post of Group D holding rank below than that of petitioners. Furthermore, there are candidates who have been recommended after expiry of panel relating to Group D. And my lord, next page, they give the names of certain persons who were lesser in marks but yet were put ahead. Specific instances. My lord, the grounds are only to that effect in the writ petition. And therefore, my lord, the prayers were, if your lordships will turn to page my lord, 1471, prayer C, prayer B, sorry. Rate in the nature of mandamus commanding respondent authorities and each of them to fill up remaining 108 vacancies in Group D by appointing your petitioners. Rate in the nature of mandamus commanding respondent authorities and each of them to set aside, resign, withdraw, cancel, wash memo dated 2nd September 2019. Rate in the nature of mandamus commanding respondents and each of them to publish merit list as already appointed in post of Group D disclosing full details including marks obtained. Now, my lord, this was the nature of the writ before the High Court. They wanted to be appointed and they said, look, you are appointing somebody post expiry of the panel. You yourself said panel is expired on 2nd September. How are you considering these people? Fair enough, no, that was a legitimate case. But that's not something on which learned judge should have issued a CBI inquiry. Turn to learned judge's order of 5th of February 2024. It is in volume 4, same volume, page 2825.
5th February.
5th February 2024. No, sorry. No. Just a sec. Give me the, my apologies. Just single judge's order. CBI inquiry.
Just 3.
Yes. See. Yes, no. I'm sorry, no. Page, volume 3, page 289. At 303. Lord, this is 22nd November 2021. As I said, Lord, July the writ petition was filed. And Lord, on 22nd November 2021, page 303, volume 3, the learned judge, Lord, passes this order. No basis at all. Doesn't consider, Lord, what was the nature of case before him. Please see. This matter started snowballing with a writ application filed on 3rd August. Allegation was that petitioners were allowed to participate in selection process, whereas some candidates below them were given appointment, and it is one specific allegation as appears in para 19 that there are candidates who have been recommended after expiry of panel relating to Group D. Then, my lord, West Bengal school certificate, exam board's affidavit is considered. Then, my lord, page 305, second para. Today, what is seen from the affidavit filed by West Bengal Secondary Education Board is surprising. West Bengal Board has stated that board is in possession of original recommendations issued by Commission with District Inspector of Schools memo. Mention upon its recommendation, and entire data was received by them in hard copies and in soft copy of 25 candidates in question, and also other recommendations of Group C and D. Now we are concerned with Group D only. Between the time period of December 2019 to February 20, they have declared that they can produce it if required. Board has said that they also issued approximately 25,000 appointments to teachers, non-teaching staff from 2018. And for all those appointments, same method has been followed. From this amendment, I understand that recommendations came from Commission, be it West Bengal Service Commission or West Bengal Regional Commission. Accordingly, board issued appointment. Here lies the most important question. If Commission or its regions did not issue any such recommendation letter which reached board's office, then how board issued appointment letters? The board has said that they received all recommendation letters, including a pen drive containing such recommendation. Now, my lord, this is on rank jumping. It has nothing to do with those who have been regularly appointed. The affidavit was limited in that regard. They admitted that yes, some 25 people have come who should not have come. Therefore, what is invisible hand who prepared and sent recommendation letters to board's office, which are invisible hands who issued recommendation letters as have been annexed to under the signature of chairperson. Corruption is writ large in the whole process of public employment, which is required to be dealt with in a firm hand. Where does the learned single judge find the basis for this in the petition? I expressed my view earlier that this state of affairs requires an investigation by CBI. Today I am going to pass such an order. However, learned advocate general said affidavit, no affidavit was called from states, etc. So learned advocate then, Lord, after all that, Lord, he says, Lord, 309, Lord. Please see, Lord, how learned judge proceeds straight away to pass the order. 308. 308. Last but second para, my lord. However, after getting the affidavit of board, I find that CBI inquiry is required to identify the miscreants in this matter by whom some letters of recommendations were issued and the board acted on that. Some letters. On the basis of board's affidavit today, I find that commission is not acting in clear hands. I direct the CBI to constitute committee headed by so and so. CBI should also inquire a very important part of this serious illegality and irregularity as to whether there is any money trail in issuance of recommendation letters and subsequent issuance of appointment letters. Preliminary report may file so and so. Without showing any disrespect to police force of the state, I am passing this order giving responsibility to CBI only for the reason that both the authorities, commission and board, as also police, are controlled by state. This is a matter of education department in a state, and in such matters instill confidence in public, etc. Now, with great respect, where was the occasion for learned judge to have done this? We have seen, Lord, what the writ petition was about. Lord, we have been working, Lord, for 4 years to the satisfaction of all concerned. Our families will be ruined, we will be ruined because of this casual inquiry. Lord, with great respect to the learned single judge, this order, Lord, unfortunately is not based on any strong premise. Yes, learned judge may have some views about politics in the state. He is entitled to. He may have personally not seen that there is something wrong. I am not coming in the way of that. But to order a limited inquiry and then take that into a full-scale inquiry by CBI and say that everything is bad, everybody must go out. This is all that was there before the court, my lord. And this can't be the basis for destroying lives of people.
That's all or something else.
Sorry?
We have understood this point.
Yes, sir. Now, Lord, please see what the CBI tells your lordship. I mean, High Court. Please turn to affidavit of CBI at page 2825. And this is very crucial. Volume 4, 2825. Lord, the High Court has really not understood this, what CBI told the High Court.
Two 2825.
Yes, Lord.
Yes.
Please see. Lord, para 3 at 2826. During investigation, it was revealed that West Bengal Central Commission had awarded work order to Nyasa Communication Private Limited for scanning and evaluating OMR answer sheets pertaining to selection test of Group D, Group C, Assistant Teacher 9, 10, 11, and 12. Investigation, so Lord, this is important, Nyasa. Investigation established that Puneet Kumar was director and Niladri Das was then vice president of Nyasa during the relevant period. It has been established during investigation Niladri Das was in charge of operations in respect of recruitment examination conducted by West Bengal Board, consequently visited office. Then para 5. Investigation has established that scanning of OMR sheets was undertaken by Nyasa at West Bengal Board office at Acharya Sadan under direct supervision of Niladri Das and in presence of WSC officials. It has further been established that Nyasa had further given work order of scanning original OMR to Data Centec Solutions, who remained present on the premises of West Bengal Commission for the scanning work. After completing scanning, process data in the form of scanned images on OMR, scanned data were handed over by Data Centec to Nyasa, who took the same to their office located in Noida in digital form, leaving the original hard copies of OMR sheets in the office of West Bengal Commission. West Bengal Commission handed over their answer keys in respect of all subjects to Nyasa for evaluation. That while scanning the original OMR sheets by Data Centec Solutions on behalf of Nyasa, 2 DAT files were generated, etc. Omit all that. Now, my lord, please turn to para 10. This is most crucial, my lord. See, my lord, how casual this investigation is and how High Court has, my lord, made a serious error in relying upon this. Para 10. That during investigation of the case, 3 hard disks were recovered on 15-16 September from residence of Pankaj Bansal, ex-employee of Nyasa. Certificate dated 16/9 under 65B of the Evidence Act from Shri Pankaj Bansal was also obtained in triplicate with regard to genuineness of data contained in 3 hard disks. Now, see, what is the error in para 11. During the investigation, data files containing scanned OMRs, DAT files pertaining to aforesaid West Bengal recruitment matters were also seized from Data Centec Solutions, not from Pankaj Bansal. And there is no 65B certificate for that. During investigation, hash value of these data files of Centec were matched with hash value of corresponding files recovered from hard disks seized from Pankaj Bansal and was found to be matching, which establishes that data contained in 3 hard disks recovered from Pankaj Bansal was not contaminated. How can this exercise be done at all? There is no 65B certificate for the OMR sheets which they have allegedly seized, which is the original data. And everybody has proceeded, the single judge has also the division bench all through that yes, OMR sheets have been found and they were tampered with. But the OMR sheets were not legally seized. And that's clearly admitted. Fortunately, the CBI filed an honest affidavit before the High Court. Nobody cared to see it. Now please see para 14 and 15. That during investigation, it emerged that in 2019, Sri Niladri Das had left NASA and started his own business in the name and style of ND Info System, was engaged in business of data processing in line of NASA. Then 15. That it has emerged from investigation before leaving NASA, Niladri Das and his staff retained all data pertaining to recruitment. How is it possible, my lord? If a statutory body, my lord, gives this, my lord, contract to party A, his staff leaves and takes away all the files. And CBI files an affidavit. Even after leaving NASA, Niladri, Pankaj and Hussain kept providing assistance to West Bengal on RTI basis on the data of NASA, which was manipulated and hosted so and so. Lord, we can't be damned on this evidence. Lord, we have also got right to life, right to livelihood.
Yes, please.
I could understand, Lord, that if I like, now, Lord, just see this one judgment of your Lordship's court, one para, and I will leave at that, Lord. Yes, Lord, please turn to, Lord, the judgment. This compilation is Lordship. Lord, please turn to compilation volume 7. And your Lordships may kindly turn to, Lord, page 471 first, para 4 and 11.
Yes.
Page 471. Lord, this is Anamika Mishra, a judgment of, Lord, a bench of 3 of your Lordship's court, 3 learned judges, my Lord. Para 4 may be seen, my lord. We heard the counsel for the parties and are of the view that when no defect was pointed out in regard to written examination and the sole objection was confined to exclusion of group of successful candidates in written examination from interview, there was no justification for cancelling written part of the recruitment examination. On the other hand, situation could have been appropriately met by setting aside recruitment and asking for a fresh interview of all eligible candidates on the basis of written examination and select those who on the basis of written and freshly held interview became eligible for selection. Now, my lord, your lordships therefore struck a balance. Now, this balance has been approved by Justice Chandrachud speaking for this court at page 299. Page 299, and lordships may turn to para 35 first. Lord, this has discussed, Lord, very beautifully the balance between, Lord, the illegalities and, Lord, not doing damage to those who are innocent. Para 35 may first be seen at page 329. In deciding this batch of SLPs, we need not reinvent the wheel. Over the last 5 decades, several decisions of this court have dealt with fundamental issue in the process.
We are aware of the case law, Mr. We need not.
No, what I'm trying to say is this. Just allow me a few lines.
You have also said so.
Yes.
If it's possible to segregate cases, and there is every possibility of segregating cases, that exercise must be done.
That's.
But if it is not possible to segregate cases, then the whole thing will blow up. Yes, you know.
I bow down, bro. But what my respectful submission is this: that no effort has been made here.
You have to.
Court has been carried away. Lord, learned single judge who ordered CBI inquiry had no basis to order such an inquiry, and the division bench has simply been, Lord, overwhelmed by the CBI, Lord, investigation. Now, the criminal case is pending. Supposing, Lord, the criminal case fails tomorrow, Pankaj Bansal is unable to, Lord, support this. What happens? All of us.
There are 2 different standards of proof required. The issues are different. Civil liability and criminal liability.
No, not on liability, Lord. We are all.
Civil issues. That's not the question they're examining. There, they'll be examining on the basis of whether who is guilty, who's not guilty.
No, not that.
Even if the offense is supposed to be committed, who is guilty, who's not guilty. Here, it's not that. That's not the issue.
I agree, Lord. But my respectful submission.
We not go on that aspect.
No. My respectful submission is that we are sought to be thrown out on the basis of that at this stage. That's my submission. Number one sentence, the court says, to treat innocent and the wrongdoers equally by subjecting former to the consequences of cancellation of entire process would be contrary to Article 14 because unequals would then be treated equally. This is what your lordship said, Lord. And paragraphs, Lord, 2 more paras 47 and 56, Lord, I commend for your lordship's acceptance. Paragraphs 35, 47, 56 and 64.
Okay.
Now, Lord, this, Lord, one more judgment. Lord, in the
need not go.
No,
that judgment has been referred to.
Just take the citation pages. I'm not going to read, Lord. Inderpreet Gehlon, Lord, at page 357, para 41 and 119. And there again, your lordship said that yes, there are some irregularities, but we are not going to send people home lock, stock, and barrel.
That we did.
So, Lord, I respectfully submit that therefore, Lord, these petitions deserve to be allowed.